Hi, I'm Christopher Burgon. I own and run Christopher Burgon Solicitors. We are a specialist litigation and commercial law firm based in London. This is the first video, the first step in the series, 6 steps for majority shareholders who want to take back control. What is the first step? Well, it is some basic company law, and apologies to you if you already know this and it's a bit too basic, but it helps me explain what follows later if we go through this now. So the first bit of basic company law is that the company is considered by the law to be an entirely separate entity from the people who are in it. The company has its own position within the law. It also has its own constitution, which is the rules that govern how the company is run. Now, usually that is set by the Articles of Association, and often there is a shareholders agreement and also directors' service contracts. And maybe in the future that constitution is altered by board or shareholder resolutions. The company is considered a separate entity under the law, and it has a constitution, that is the set of rules by which the company is governed. Now, the constitution is made up of the company's Articles of Association. Most companies are set up with people adopting the model Articles of Association. Nothing wrong with that. That's what I did with my company. But often as well, those articles are amended, and they may also have additional provisions through shareholders agreements and directors' service contracts, and maybe also shareholders' resolutions have amended the articles as the company has progressed. There you go, you have a company, it's a separate entity, it has its own rules. Within the company you have 2 groups of people. You have directors and shareholders. Now, these videos are for people who are both directors and shareholders simultaneously. But what's really important to understand is that directors and shareholders are entirely separate roles. Now, the question is, out of the directors and shareholders, who controls the company? Well, if you look at the model Articles of Association, that is the standard Articles of Association that haven't been changed, Part 2, Section 3 says that the day-to-day running of the company is the responsibility of the directors, who are allowed to manage the company with the full authority of the company. So if you read that, you're thinking the directors are the ones in charge. However, keep reading. Part 2, Section 4 of the model articles say that the directors can be overruled if the shareholders pass a special resolution. A special resolution, according to the Companies Act 2006, requires 75% of shareholders. So who's in charge of the company? Well, it's the directors on a day-to-day level, but they can be overruled by 75% of the shareholders. So if you've got 75% or more of a company, then you're the one in charge. I had a client who was a construction business on the eve of lockdown for the pandemic, all those years ago now, 5 years ago. There was a board of directors, there was 5 directors, and they kept outvoting the founder, the owner of the business. He wanted to save the business, do the best that he could for his employees and clients. They wanted to line their own pockets. They kept outvoting him on the board and saying, we're the board of directors, you have to do what we say. But my client had 80% of the shares. So he could overrule anything that the board of directors did, or anything that the board of directors could do, and that's what he did. He exercised his control and took control of the company. So 75% of the shares, and you're the one in charge regardless of what the directors think. What if you don't have 75%? Well, these are videos for majority shareholders, and the definition of a majority is 51% or even 50.1% of the shareholding. If you have 51% of the shares, then you are a majority shareholder, and you can remove directors. Section 168 of the Companies Act 2006 says that a director from a company can be removed by passage of an ordinary resolution. Now, that means that 51% of the votes are required to pass an ordinary resolution. Going back to the construction company, our client who had 80% of the shares, the board kept outvoting him. That's what he did. As well as overruling the board, he used his authority to remove each of the directors so that he was the one in charge. So there you go, heading towards the end of the first video. who's in charge of a private limited company. Remember, the company has its own identity, its own rules through its constitution. The directors are responsible for the day-to-day running, and they have a lot of power. They have the full power of the company, but shareholders can either overrule the directors with 75% of their shareholding, or they can dismiss a director with 51% of the shareholding. And that's it. If this is of interest to you, if you find yourself in a position where you need to exercise control over a private limited company, then please get in touch. Getting in touch with us is easy. You can go on the website, press the book a meeting button and pick a time and date that suits you from my calendar, or please drop us a line on an email or give us a call and we'll call you back, or leave a comment underneath this video. Thanks very much.